Hi, welcome to the sixth session. In the previous session, we discussed about family codes, followed by group codes, which express themselves in the form of professional ethics. And there is a set of larger codes which govern the nations as well as their respective people across the world. And at the national level, they are the constitutions, and at the international level, they could be declarations of various kinds, like, for example, the Universal Declaration of Human Rights, 1948, which was passed by the UN General Assembly, and that laid the foundation for various national laws relating to human rights. So we have these macro level codes which bind us, regulate us, and lead us in a particular direction. So closer home, that is, now let us talk about our own Indian constitution. You know that on the 26th January 1950, India became a republic and the constitutional sovereignty and supremacy has been established with effect from that date. Now, I don't need to say this to you, you would all be aware of this, that the constitution is the supreme law of the land, and it is the source of all authority of the government, that is in the executive side, the legislature, as well as the judiciary. Apart from establishing certain constitutional institutions like the Finance Commission, the Election Commission, etc. So, one logical question that comes up is the Constitution of India a legal code or a moral code, or is it a bit of both? To my mind, it's a bit of both because it is the supreme law of the land, and it creates the source of authority for it is the source of various institutions. So no law can be, no one can be beyond or above the constitution. So constitution being the supreme law of the land. So here, if that is the supreme law of the land, then it has to be necessarily a legal code. It cannot be a moral code in the normal sense. In the common sense, that is how it would be telling us. But that is not entirely the case because there are also parts of the constitution which are not justiciable, in the sense that for violating it, you cannot go to a court of law and then ask the court to sit on judgment on any one of those three components. What are they? To my mind, number one is preamble, number two is the directive principles of the state policy, and number three, the fundamental duties. Now, preamble is the opening statement of the Indian Constitution. In fact, for some years there was a debate whether preamble is in fact a part of the Constitution or it is outside the Constitution. But that is more or less settled now. That preamble, in a manner of speaking, reflects the basic structure of the Constitution, And it also probably lays down the moral vision of the framers of the Constitution at that point of time. You must have heard that recently Maharashtra government has issued a direction that the preamble of the Constitution must be recited by the students in both primary and secondary schools of the state of Maharashtra starting this Republic Day, that is 26th January 2020. And the stated objective of that particular direction of the government is that it will instill among the students a certain understanding of the constitutional values. They said constitutional values, what are they? They were talking about whatever the preamble has said, possibly, that is justice, liberty, equality, and fraternity. These are the four essential principles that have been laid down in the preamble of the Constitution. You must have read it. It says, "We the people of India." We the people of India. So, why constitutions are above? Because the people being the direct sovereign, so they create a constitution, and constitution creates certain institutions. So obviously, the baby cannot outgrow the parent. So whole source of all the authority of these three institutions, like executive, legislature, and judiciary, they flow out of the constitution. So therefore, constitution can be amended. It's not that it is not amended. It's been amended more than 100 times. But through a certain power that is provided to the parliament under the constitution itself, by the constitution itself, under Article 368 1 of the Constitution. So, therefore, it's not that it is beyond amendment, because amendments have taken place, but within the power that has been very clearly laid down by the Constitution of India. And you must be aware that it's not an ordinary law. Amending the Constitution is through a different process and through a special process, as very clearly laid down by the Constitution itself. Now, Maharashtra government's decision seems to be very sensible, because the children of the country should know the Constitution and what kind of values it tries to espouse and then enforce among the people of her country, in fact, people of our country, that is. Now, the other component, in addition to preamble, is the directive principles of state policy. The state is supposed to move within a framework, and that framework has to be laid down by the constitution. Even if the directive principles of state policy are not justiciable, the courts have consistently and regularly sought recourse to the directive principles of state policy whenever there were issues that required deeper and detailed discussion. And whenever they required some kind of a moral framework for judging a state's actions or for pushing the state to do certain things, they refer to both the preamble as well as the directive principles of state policy, which are a part of the constitution under part 4 from articles 36 to 51. Now 51A is something that has been added later as a part of the 42nd amendment to the constitution, wherein certain amendments had been made both to the preamble as well as a new article 51A was incorporated into the constitution through amendment. That is a 42nd amendment that was brought in during the emergency period by Mrs. Gandhi when she was the Prime Minister of India. Now, the directive principles of state policy, as well as fundamental duties and the preamble, nobody can take a recourse to it directly, recourse to them directly, and knock the doors of judiciary, saying that this particular aspect of the preamble or the directive principles or the fundamental duties have been has been violated. And unlike the directive principles of state policy, which broadly regulate the behavior of a state, behavior of the government, the fundamental duties are actually meant for the citizens of the country. Just the other day, the Honorable Chief Justice of Supreme Court also had made a statement about the citizens not just being concerned about the rights, they should also be concerned about their duties. That's what he said. And it was the prevailing mood of the nation at that point of time, perhaps, or at least mood of the government, that there is too much of license in the country, and citizens don't seem to even have basic responsibilities toward the nation. So therefore, it is necessary that we must have a set of duties that lay down the literally the conduct rules for citizens of the country. Now that was probably a very wise and right thing to do at that point of time, and possibly even now also they hold good. Here one interesting case, and in the fundamental duties when you go through, and I think there are about 10 initially and then one was added later, total 11 I think they're there. Especially respecting the national symbols and then national honor and the rule of law, and these are all fundamental duties, and I'm sure they're all available and you can read them through once at least. There was an interesting case in Kerala. There was a Christian denomination by the name Jehovah's Witness. So people who follow that faith uh, have probably been proscribed against saluting any symbol other than the person who has founded that particular faith. So the students of a particular school, they stood up when the song national anthem was being sung, but they didn't sing. So they were expelled from the school or suspended from the school, and then Kerala government took it very seriously because there was a standing instruction. Here, one point I need to tell you here is that even though fundamental duties and directive principles of state policy are not justiciable directly, the government can come up with an act under it. A law can be made in furtherance of any of those principles that had been laid down. In this particular case, there is a particular act called uh, Prevention of Insult to National Honor Act, I think 1971. So, in that act, it was very clearly laid down that the symbols of sovereignty of Indian state will have to be respected. So the matter went up to Supreme Court because the students, their argument was that we never insulted our national flag we or anthem. It is just that we stood up, but we didn't sink, because there is a certain prescription which has been made in our own religion, so it makes it difficult for us to do so. That case is, I think, you can read a little more about it. It's a very interesting case. uh, Bijoy Emmanuel versus State of Kerala, 1973 or 74. I don't remember that. You can just uh, check for that. Supreme Court took a slightly liberal view because they were all children, and they said it's okay. I mean, they have not insulted because they never had the intent to insult the national flag or national anthem. They stood up out of respect, but they didn't sink. That in itself doesn't amount to insult. This is what Supreme Court had said. So whether you agree or don't agree with that particular decision, that was the judgment as on that date. So effectively, fundamental duties, they regulate us. The directive principles of state policy, they regulate the state itself, they regulate the government itself. The preamble, so long as it was felt that it was not a part of the constitution, so whatever was there in the preamble didn't really uh, become directly justiciable. But subsequently, I think post Keshwananda Bharati versus Government of Kerala case in 1973, the Supreme Court discovered this expression called the basic structure of the Constitution. Preamble is not enforceable, it is not justiciable, but tinkering with any of the values that have been prescribed in the preamble by the framers of the Constitution would tantamount to breaking the very spirit of the Constitution. That was how the concept of basic structure of the Constitution was expounded by the Supreme Court at that time. So you may be aware that even the preamble was amended through the 42nd Amendment of the Constitution. Uh, they added two words, socialist and secular, to the Constitution, and then they also added, earlier it was just a democratic uh, republic, and then they added that socialist and secular republic. And they have also added another word in through that amendment, that is called integrity, after the word unity and integrity of the nation. These are the two changes that they have made to the preamble itself. So it's not that uh, they cannot be amended. Preamble was itself amended, and directive fundamental duties have been added under 51A of the Constitution. So even directive principles of state policy also have been at various points of time touched by the parliament. So the limited point that one needs to know here is that these national codes can be like Constitution of India, at least. We're not talking about other countries. Countries where there are no written codes, there are no written constitutions, things may be slightly different because then the conventions will come into play. But countries like ours, where there are written constitutions, like ours, United States, etc., but whereas in Britain you don't have a written constitution, so their conventions matter, practices matter, and they are all very zealously guarded actually by various institutions that are earmarked to protect their conventions, and they're very particular about it. And but in countries where constitutions are very well written down, there is hardly any scope for interpretation in the normal courts. But still, the judiciary, whenever it feels that there is a necessity for them to intervene, especially in troubled times, they do interfere, and then they do interpret uh, to the extent that a constitutional amendment also became uh, became available for judicial review, which earlier to earlier to Keshwananda Bharati was not really looked into by the judiciary, but post Keshwananda Bharati now, if a constitutional amendment is made by the government, by the parliament, and that also can be looked into for its adherence to the constitutional principles. Now, that is how the present status is. Okay, now just one more thing before I close. There is an expression called constitutional morality that has gained circulation of late. In 2018 itself, in 10 judgments of the Supreme Court, this expression constitutional morality has appeared, has started. Now it is gaining currency all over. What is this constitutional morality? In the Constitution itself, the word morality appears only 4 times. Twice under Article 19, 19.1, and I think 19.3, and once again under Article 21. One is that freedom of speech, and there is freedom for that religious expression, preaching, practicing, and professing religion. So the word morality also is used in the sense of decency and public order. That is how it has been used in all these uh, expressions that appeared in the Constitution. So these 4 occasions have never, nowhere in the Constitution there is an effort to define morality or to subject some of these constitutional principles to morality, etc. There's no effort of that. There's no conscious effort on that. So whatever values they wanted to uphold through the Constitution have been very well laid down in the moral vision of the uh, framers in the preamble itself. In the preamble itself, they used 4 expressions: equality, liberty, fraternity, and justice. These four are the foundational principles of the Indian Constitution as available to you in the preamble of the Constitution. These are all values. So all laws that the Parliament makes have to uphold those principles of the Constitution, and there cannot be any deviation on that. Is the substance of the Keshwanand Bharati case. That is basic structure of the Indian Constitution, and that is what they felt. But where has this expression constitutional morality uh, where has this come from? I I started wondering about it because this is probably another discovery, like the way the basic features of the Constitution, a basic structure of the Constitution was discovered by the judiciary at some point of time. Like that only, I think, in the 377, when they were striking it down in that Nas versus, I think, state of Delhi or some case, in that case, recent case. So when they were striking down some of those offending clauses of that particular act, particular section 377 of the Indian Penal Code, that's when possibly the judge made a comment that, the judges have made a comment that public morality, the constitutional morality cannot be the same as the public morality. That is how that expression, that sentence was structured. To my mind, the expression constitutional morality is a bit of an oxymoron. I would like to take constitution as a legal code, and once something is enacted under the law, so long as it is not declared as unconstitutional by the judiciary, it should count as law. And constitution, to my mind, is therefore a legal code only. The word constitutional morality perhaps refers to the values that have been incorporated in the preamble of the Constitution, and those are the values that the government of the day or the parliament of the day have to conform to. That probably is the meaning of that expression constitutional morality. And otherwise, constitution being a legal code, bringing in morality into this expression called constitutional morality somehow doesn't make sense to me. But the sense in which Dr. Ambedkar may have used this during the debates when he was moving this resolution in 1948 for adopting the constitution sometime in the month of November, uh, he had quoted a Greek historian by the name Grote, Grote, and then said that word was possibly used by a Greek historian at that time, and then that was repeated by Dr. Ambedkar, and then he had said that I will hope that the institutions that have been created by the Constitution, they respect the constitutional morality. Somewhat in that line, he had made a statement. So the sense in which he used probably is that the values that have been espoused by the Constitution, the framers of the Constitution, will be respected by the various institutions of the Constitution, created by the constitutions like executive, legislature, and judiciary. Probably that is what he meant. Uh, but people, again, this is open to a lot of discussion. My word is not necessarily the final word here. I think you may need to spend a little more time trying to read more about this word, this expression, constitutional morality, uh, and uh, and maybe discuss with some of your friends who are also preparing for this examination. So now I kind of conclude this part. Among the First we discussed the legal codes, and now we discuss the moral codes. Now I conclude by saying that constitution is a mixed bag of legal code laced with a little bit of moral code, more in the form of laying down the vision rather than actually trying to uh, come up with any law relating to that or any code relating to that. And then there is a set of international codes which also lay the foundation for respective states to come up with laws related to that. And I quoted the example of Universal Declaration of Human Rights of 1948, and that led to various countries of the world coming up with their own respective acts relating to protecting their human rights. So this kind of closes the discussion relating to legal and moral codes. Now, the next what we have is the religious codes, which also have a lot of influence on human beings. And let us discuss that in the next session. Thank you very much for being with me.